Myth number one. I always hear this all the time. Lisa, I'm just hanging on so I can make those 10 years. For what? And most of the time when you say for what, then people don't really know. Hey, it's Lisa Knox here, owner and founder of Knox Law and Mediation, serving the great state of Florida right here in sunshiny Tampa Bay. So, as you all know, I practice family law here in the state of Florida. And, I ran across some really interesting situations, stories, clients, potential clients, and so forth. And I thought it would be really great to share some information with you all. So now we have a new topic. It's called MythBusters. We all have those old wives' tales that we've heard, all those things that, people say to each other that, may be true, may not be true. We really don't know who said it, but your great uncle Leroy's cousin, Samantha's niece, Clara, best friend, came to you and told you that when they were going through their divorce back in 19 whenever, that this is what has happened and this is the standard. And so here you are believing it. And should you believe it? I don't know, So let's see if we can address some of the most common ones, or at least the ones that I've heard and all. And if if you've heard it too, feel free to post a comment or to let us know, or if you need to follow up on it, absolutely feel free to give us a call. Okay, let's go into it. Now, keep in mind, all of these myths are family law related, right? And each state governs how they manage family law issues. So I'm telling you that because if you're listening to me and you're in New York, or if you're checking me out in California, it may not apply to you. So if it doesn't apply, let it fly. Just enjoy the conversation, all right? All right, so here we go. Myth number one. I always hear this all the time. Lisa, I'm just hanging on so I can make those 10 years. I'm just hanging on because I'm at 9.5 years and I just want to make those 10 years. For what? And most of the time when you say for what, then people don't really know. They say, oh, because, then that way I can get, half of the retirement or half of the benefits or anything like that. Ooh, so here's the question. Is that myth true, or is it based on any truth? And the answer is sort of. So here in the state of Florida, right, you do not have to be married for a certain length of time before you are entitled to a portion of your soon-to-be ex-spouse's retirement, investments, accounts, whatever. As a matter of fact, to be honest with you, all you have to do is be married, and anything that, your spouse gains, earns, incurs, whatever, and the same with you, from the day that you all are married until the day that you file, or whatever other date you all agree on, well, that's subject to being divided. And so you're subject to getting a portion of it. Okay? So in that way, no, if it's 3 years and you're ready to throw in the towel, throw in the towel. Call it what it is and it's done, honey. All right? But now, let's talk about that sort of part, that part that's sort of based on a little bit, a small smidget of accuracy, and it's just a very small smidget of accuracy. And so here's where it goes into play. It's really more so in play for two purposes. The first purpose is if your soon-to-be ex is a member of the military, or a former member of the military, and their military retirement benefits are at issue. And that is only in part, okay? Requirement is that in order for an order dividing your soon-to-be ex's military benefits with you, in order for that to be enforceable and paid directly to you, meaning not having to go through your soon-to-be ex-spouse who would then have to pay you, but paid directly to you from the Defense Finance and Accounting Service, DFAS, to you, and enforceable under the Uniformed Services Former Spouses Protection Act, known as the USFSPA Act. It's very common. in order for that to happen, you would have had to have been married for 10 years while your spouse was performing at least 10 years of that military service. So that's the 10-year rule. Basically, hey, if you're married for 10 years and you're entitled to your soon-to-be ex's military retirement, then we can pay you directly. DFAS can pay you directly, and it's enforceable under that act. If you're not married for 10 years, doesn't mean that it's not enforceable, or that it's not, that you're not entitled to the retirement. It just means it's not enforceable under that act. It just means that DFAS is not going to pay you directly. You know, your soon-to-be ex-spouse will be paying you directly, or we can do all kinds of other agreements in its place. That's all that means. So once again, you don't have to stay married for 10 full years in order to get those military benefits. Now, the other thing that sort of has some relevancy in the 10 years is Social Security benefits, right? If you wish to get your soon-to-be ex-spouse's Social Security benefits, even after you divorce, right, you would need to be married with that person for at least 10 years. Here's the thing. That is really important if you meet all the other requirements as laid out by the Social Security Administration, right? And so that entitles you to your soon-to-be ex-spouse's Social Security benefits. And it's also key if your spouse's, soon-to-be spouse's benefits are going to be more than your Social Security benefits. Back in the day, it was a little bit more, I want to say weightier. I wouldn't say more important, but a little bit weightier, especially when there was a situation of the husband typically being the bread winner and the highest earner and the provider in the household and so forth. And women were typically stay-at-home wives or stay-at-home moms. And so they didn't have the same accrual from work. They didn't have the same amount of benefits from work. Now that we're living in sort of like this 50-50 world, you know, women are out, they're earning, and they are sometimes out earning their men or their women, you know, their other spouses and so forth. And so the necessity for your spouse's benefits are not always as important on the line. So what does it boil down to? No one can tell you what to do with your marriage. No one can tell you what to do with your plan. Typically, I find that people who say, well, Lisa, you know, I know it's year 4, but I just want to hold on for those another 6 years so I can make it to year 10. Once they realize you don't actually have to make it to year 10, a lot of times they still decide they want to just try and make it to year 10 just for whatever reason, I guess. And so that sort of boils down to maybe they're just not ready to say goodbye. But if you are ready to say goodbye, you are truly ready to say goodbye, and you are just looking for a sign that sets you free and allows you to go, lets you have permission to say, you know what, I don't need all this other stuff. Let me run and go get my freedom. Here is your sign. Run, go get your freedom. You don't have to wait till year 10. Year 10 is not the year to win. You can go ahead and go now and go get your happiness. All right, so I hope that clears everything up. If you have any more questions about 10 years, retirement, Social Security benefits as a divorced spouse, enforcement of final judgments, or if you are fortunately or unfortunately looking at getting a divorce and changing your future, please feel free to give us a call, 813-447-3001, or you can go to the website, lmknoxlaw.com. We are always here. We're always here to answer any questions that we can. And in the meantime, we're always wishing you the very best of everything. Okay, I'll talk to y'all soon. Bye.